speaker number 1. I ask permission from the bench to refer to you as collectively as ladyships. Much obliged, Your Lady. Your Ladyships, we are not arguing the maintainability of the matter, as this matter has already been admitted and it is now listed for final hearing. So we will be going on to the arguments at once with your permission. The very first issue before this Honorable Court is that the provisions of the Surrogacy Regulation Act 2021, to the extent that they prohibit unmarried couples from availing surrogacy, are not constitutionally valid. We humbly submit as petitioners that the provisions of the Surrogacy Act are not in consonance with the constitutional provisions. My ladies, the sections in question, if I may draw my ladies' attention to page number 7 of the written memorial. The sections in question are section 4.3 subclause C and section 2S and section 2R. Under these sections, your ladyships, only couples that are married and between the age of 23 to 50 years and between the age of 26 to 55 years are allowed to avail the provisions under this act. Moreover, an intending woman means an Indian woman who is a widow. From page 7 of the written submission, my lady. My lady has it? My lady has it? Under these sections, my lady, there are only 2 categories of persons who are allowed to avail surrogacy. It is most humbly submitted before this Honorable Court of Zindia that due to this Act's restrictive nature, only a limited number of persons are allowed. In addition to that, the entry barrier to avail the services under this Act is so narrow that only proven infertility can make you avail the services under this section. The Act under this section has precluded individuals who have other health issues that may not amount to infertility, like high blood pressure, anemia, diabetes, ovarian cysts, which may not amount to infertility, but at the same time can create several medical complexities for the mother that make her infertile, but at the same time not proven infertility. Although under section 4, subclause 2, clause E, it does mention that there are several conditions where the surrogacy board specifies where a condition and a disease can be allowed, but at the same time, the vagueness of the conditions under this statute is persisting and is subject to the opinion of the board. According to Lord Macaulay, if I may draw my lady's attention to page 8, the rear end of the page, a good code should have the qualities of precision and comprehensibility which is absent under this statute. In a letter to Lord Auckland, Lord Macaulay states, there are 2 things which a legislator should always have in view while he is framing the laws. The one is that they should be as far as possible precise. The other is that they should be easily understood. That a law, especially a penal law, should be drawn in words which convey no meaning to the people who are to obey it is an evil. Under section 4, subclause 2, clause E, my ladies, it is mentioned that the proven infertility is under the opinion of the surrogacy board and thereby making it exceptionally vague. Moreover, and as laid down in the Minerva Mills Limited versus Union of India and others, there is a test, the Golden Triangle test, where Article 14, 19 and Article 21 of the Constitution have to be followed in order to ensure that the state does not infringe on an individual's rights. What the statute has done is that it is not even allowing married couples. The respondents may argue that only unmarried couples are not allowed under the statute. However, what they have failed to understand that even married couples without proven infertility are not allowed to avail the services under this act, making the entry barrier so narrow, making the statute itself useless. Moreover, these provisions have made parenthood nearly impossible for the LGBTQ+ population and reinforces society's typical patriarchal values by assuming heterosexual marriage as the foundation for parenthood. As we all know, the judgment of Navdeep Singh versus Union of India, the Honorable Supreme Court observed, if I may draw my ladies' attention to page number 12 of the written memorial, history owes an apology to the members of this community and their families for the delay in providing redressal for the ignominy and ostracism that they have suffered through centuries. The members of this community were compelled to live a life full of fear of reprisal and persecution. This was on account of the ignorance of the majority to recognize that homosexuality is a completely natural condition, part of a range of human sexuality. This misapplication of this provision denied them the fundamental right to equality guaranteed by Article 14. It infringed the fundamental right to non-discrimination under Article 15 and the fundamental right to live a life of dignity and privacy guaranteed by Article 21. Justice Chandrachud also in his concurring view in the preceding judgment observed that members of the LGBTQ community cannot be ignored while securing constitutional rights. They are entitled to full range of constitutional rights and equal treatment of law and an equal citizenship. This act excluding the LGBTQ plus community is itself violative of the precedents laid down by this very court, my ladies. It is humbly submitted that Zindia is a secular country, and if any secular law is brought by the government in this country, then it should be for every single person of this country subject to reasonable classification and not for an arbitrary class of people. This act permits surrogacy solely between married couples and thereby exclude members, apart from the LGBTQ community, they exclude live-in couples, single, divorced or bereaved parents, thereby criminalizing their reproductive autonomy in this regard. These provisions also exclude a major portion of society like unmarried females who wish to experience motherhood and are unable to conceive. The irony here lies in the fact that under the Medical Termination Pregnancy Act 1971, if I may draw my ladies' attention to page number 10 of the written submission, the act punishes them for having a pregnancy by forcing them to have the child. While herein, when an unmarried woman wants to have a child but is unable to bear, she is not allowed to avail the surrogacy services. An order passed by Judge Swati Chauhan of the 9th Family Court in 2017 reads, "Right to reproduce is a very intricate feminine right emanating from women's basic human rights. Not allowing a fertile woman to procreate is like compelling her to sterilize, to curb or to curtail reproductive right may have subtle and devastating demographic outcome." Furthermore, my lady, under the Bombay High Court on its own motion versus the state of Maharashtra stated that human rights are natural rights and thus a woman has a natural right in relation to her body, which includes her willingness to be a mother or her unwillingness to be a mother. Woman owns her body and has rights over it. Furthermore, it is submitted that as per the Assisted Reproductive Technology Regulation Act, a single woman above the age of marriage is eligible to avail the services under the Assisted Reproductive Technology Act. However, if she is unable to bear the child due to bodily complications, she is denied the right to avail surrogacy under the Act, making these two acts, that is the Assisted Reproductive Technology Act and the Surrogacy Act, who have the same objects, completely inconsistent with each other. Furthermore, if I may draw your attention to page number 12 of the written submission, in the Baby Manji Yamada versus Union of India, the Supreme Court had to first deal with the question directly linked to surrogacy for the very first time. The court therein recognized surrogacy as a medium of embracing parenthood and accepted that the parent may be a single parent or a homosexual couple. The Honorable Supreme Court stated that intended parents may arrange a surrogate pregnancy because a woman who intends to parent is infertile in such a way that she cannot carry a pregnancy to term. Examples include a woman who has hysterectomy, has a uterine malformation, and also has a recurrent pregnancy loss or has a healthy condition that makes it dangerous for her to be pregnant. Furthermore, the pertinent part of the judgment is that this judgment accepted that a female intending parent may also be fertile and healthy but unwilling to undergo pregnancy. This very court held that if the female is unwilling to undergo pregnancy, the intended parent may be a single male or male homosexual couple, but they may be allowed to avail the services of the Surrogacy Act. Moreover, my lady, in the case of Anwar Ali Sarkar versus the state of West Bengal, it clearly laid down two clauses, which is intelligible differentia, which distinguishes two people grouped together, and also that the differentia must have a rational relation to the object sought to be achieved by the act. This act aims to enable people who are unable to have a child to avail surrogacy services. But with their restrictions, they have made the entry barrier so narrow that it is impossible for most people to avail any services under this act, making this act completely void under section 13. And moreover, the intelligible differentia and the reasonable classification and rational relation as per the Anwar Ali Sarkar judgment is not found in this case. If I may move on to the second sub-issue, which is Article 19, that the provisions of this Act are not in consonance with Article 19G of the Constitution. If it may please, my lady. It is most humbly submitted before this Honorable Supreme Court of India that the Act disregards the strength of a contract law in enforcing a surrogate's rights. In case commercial surrogacy is allowed, there is a contract which will be legally enforceable before any court of law. Moreover, it violates the article as surrogates, they want the surrogates to work for free. They are compelling them to do reproductive labor for free by banning commercial surrogacy, as under altruistic surrogacy, only the medical expenses and the insurance is covered. In a country like India, where a lot of women's opinions are according to their own families, most of the women in the families will be forced to go through procedures like this and completely for free. This will be contrary to what the Act intends, that is not exploitation of women. Moreover, I would like to point out a very important judgment in this case, if I may draw my ladies' attention to page number 14, point number 18. This very court held in the state of Maharashtra versus Indian Hotel and Restaurant Association that a total prohibition of bar dancing is unconstitutional because it results in many women being forced into prostitution and violates Article 19(1)(g) of the Constitution's right to carry on one's profession or occupation. My lady, it is pertinent to note here that the Supreme Court itself held, even though bar dancing might be completely indecent to public morality, the Supreme Court itself held that it cannot be barred completely and that will be declared as unconstitutional. Something like surrogacy, which is a noble thing and might be useful for people who are unable to bear children of their own, being completely banned is absolutely unconstitutional. The fact that the surrogate bearing the child for the intended couple will be allowed as altruistic surrogacy, but at the same time, the difference is that she will be exploited just without any kind of monetary compensation. Additionally, any blanket ban or partial prohibition in this matter will push the sector entirely underground. As of now, the sector is, before the commencement of this act, the sector was a multi-million-dollar sector, and therefore this act jeopardizes My lady, if I may just draw your attention to page number 15, in the case of State of Maharashtra versus Indian Hotel and Restaurants Association, point number 23. It states that a state cannot satisfy its burden while making a restriction on an article under Article 19(1)(g) if there is insufficient data to show harm. The state has not shown any data as to how the exploitation of surrogate mothers are taking place. The act itself is very new. Under Assisted Reproductive Technology Act also, there is no reliable data to show how the women are being harmed. And since there is no reliable data to show to the effect, my lady, under this precedent, the state cannot satisfy by just simply banning it because it is unable, because it presumes that there may be exploitation of women. My lady, if I may go through the other sub-issue, which is Article 21 of the Constitution of India. the counsel for the petitioner submits that it is not in consonance with Article 21 of the Constitution of India. In BK Patarsati versus Government of Andhra Pradesh, it was clearly held that the state's interference with procreation constitutes a direct infringement on one's own right to privacy. Moreover, this very court also held in the case of Suchitra Srivastava that there is no doubt that a woman's right to make reproductive choices is also a dimension of personal liberty. My lady has it? Page number 16. There is no doubt that a woman's right to make reproductive choices is also a dimension of personal liberty as understood under Article 21 of the Constitution of India. Moreover, the Law Commission of India, while suggesting the report on surrogacy, also stated if reproductive right gets constitutional protection, surrogacy, which allows an infertile couple to exercise that right, also gets the same constitutional protection. My lady has it? Therefore, it is humbly submitted that the provisions of the Act are not in consonance, as stated by the Law Commission, that and by several precedents, that reproductive right has constitutional protection, and since they have constitutional protection, the rights of an infertile couple to exercise that right also gets the same constitutional protection. And while enforcing this Act, the legislators have not paid heed to the Law Commission of India, which stated the statement. Moreover, the provisions of the Act are not in consonance with the international covenants that were given, which clearly states that the right to family formation guaranteed under Article 16 of the Universal Declaration of Human Rights. Moreover, it also goes on to state in detail that they can choose freely and responsibly the number and even the spacing of their children. Therefore, it is humbly submitted that a public policy, as per the Muralidhar case law, my ladies, that public policy cannot stay static within a society, but changes over time and even within the same generation. Public policy is pointless if it is always confined to predetermined molds. By allowing only married couples, and married couples that too of a specific age, the statute is pushing for traditional family structures, and it is not allowing itself to broaden and to allow other singular families to come under the provisions of this Act. Moreover, my lady, as I have submitted that these provisions are not in consonance with Article 14, 19 and 21, the Council would like to make one last submission under Article 13 of the Constitution of India, which states that any act that is not in consonance with the provisions of the fundamental rights guaranteed under the Constitution of India is void ab initio. As stated in Deep Chand versus State of UP, post-constitutional law made under Article 13(2), which contravenes fundamental rights, is nullity from its inception and is a stillborn law. It is void ab initio. Moreover, my lady, it is humbly submitted that the legislature has to look at the progressively to the rights of the citizens in order to live up to the expectations of the founders of the nations, as stated in the state of Kerala versus Thomas and others. The purpose of having a constitution is to foster the growth of the rights and transform the society, and not to go against the provisions and to establish an act that is completely against the provisions of the Constitution of India. Moreover, my lady, the final issue is that the eligibility certificate, that is the certificate of infertility, which is granted to the couple to avail the services of surrogacy under the Act, is blatantly demeaning. The infertility certificate, my lady, it is a long process to get that, first of all. And secondly, mandating a couple as entirely infertile and making them go through such procedures in a country like India, where it is still a taboo, is demeaning and is not in consonance with any of the rights that are guaranteed under the Constitution of India. Moreover, as stated in the Rajgopal case law by this very court, the right to privacy is implicit. My lady, may I ask for extension of 1 minute, please? Yes, my lady. Therefore, the Council submits that under the issues that are submitted and as per the Harish Jagtiani judgment, all these precedents merely state that reproductive right is a private right and it does not involve the state. It should not have such major stringent restrictions when the acts itself want the couples to avail the services and to go through that process so that they may have a family. Therefore, it is humbly submitted that as per the precedent stated, I shall now call upon my co-counsel to argue on the further issue. My lady, my very first submission was that only, that even unmarried couples, even married couples under the Act cannot avail the services if they do not fall into a particular age group. That is the reason we are saying it is arbitrary. Moreover, proven infertility will allow you to avail the service under the Act. Other infections like uterine fibroids and several other diseases that may make a woman might be fertile, but at the same time she may not be able to carry the baby to full term. Even that is not allowed in case of a married couple. So even within a married couple, there is a lot of arbitrary classification, and these diseases are subject to the opinion of the medical board. If the medical board says yes, she is infertile, only then she can even then go forward despite being married. Therefore, the council submits that it is arbitrary because there is no properly laid down provisions. As I said in Lord Macaulay also, that the statute itself is not very precise. It is not mentioning which conditions. It is just stating proven infertility and rest is subject to the opinion of the board. Thereby, it makes it completely arbitrary even within the class of married couples. I hope I have satisfied my lady.
Your Ladyship, may I start? Your Ladyship, this is Council number 2, and I seek your permission to discuss whether provisions of the Surrogacy Regulation Act 2021 to the extent that they prohibit commercial surrogacy under the Act are constitutionally valid or not. Before I begin with my submissions, may I submit a court order of the Supreme Court to the bench. It's passed on 26 September 2022. And a similar petition has been already filed in the Supreme Court and which is pending for hearing by Arun Muthuvar. Can I just submit this copy? Court clerk? It's a humble submission to the bench that the matter may be decided today and a judgment may be passed by your Ladyships, which will be binding on all the courts of the country under Article 141 of the Constitution. Your Ladyship, the present petition challenges the prohibition of commercial surrogacy under the Surrogacy Regulation Act 2021, arguing that it is discriminatory, restrictive and violative of Article 14, 19(1)(g). Further, it is also contended that the provisions of the Surrogacy Act 2021 have led to a direct infringement of a woman's reproductive right, which is a right guaranteed under Article 21 of the Constitution. Your Ladyship, surrogacy under the Black Laws Dictionary is defined as an agreement wherein a woman agrees to be artificially inseminated with the semen of another woman's husband. She agrees to conceive a child, carry the child to term, and after the birth, assign her parental rights to the biological father and his wife, the biological mother. Under the Regulation Act 2021, there are two surrogacy procedures, commercial surrogacy and altruistic surrogacy. According to the Act 2021, commercial surrogacy under Section 2G means commercialization of surrogacy services or procedures or its component services or component procedures including selling or buying of human embryo or trading in sale or purchase of human embryo or gametes or selling or buying or trading the services of surrogate motherhood by way of giving payment, reward, benefit, fees, remuneration or money incentive in cash or kind to the surrogate mother or her dependents or her representative except the medical expenses and such other prescribed expenses incurred on the surrogate mother and the insurance coverage of the surrogate mother. Whereas the altruistic surrogacy is defined as under section 2B, which means the surrogacy in which no charges, expenses, fees, remuneration or monetary incentive of whatever nature except the medical expenses and such other prescribed expenses incurred on surrogate mother and the insurance coverage for the surrogate mother are given to the surrogate mother or to her dependents or her representative. The prohibition of commercial surrogacy has now led to criminalizing the trade under the Act 2021. Prohibiting commercial surrogacy and criminalizing it under the Act is unconstitutional in nature as it infringes individuals' fundamental rights under Article 14, 19(1)(g) and 21 of the Constitution. The restrictions under the Act allow only heterosexual couples intending couples to avail of commercial surrogacy only when they pass the test of essentiality certificate, which my co-counsel has already explained to the bench. After the prohibition of commercial surrogacy, the intending couple and the intending woman under the Act are forced to opt for altruistic surrogacy. This kind of surrogacy forces the intending couple or the intending mother to look for a surrogate mother who is genetically related to either the biological mother or biological father. This allows only a limited number of people to experience the happiness of becoming a parent, which is the most precious gift. This is a clear violation of fundamental rights of all the intending couples and intending women failing under the Act. It is also pertinent to note that the research papers have shown that when there is a biological connection between a husband and a wife, there is a high chance of a child which is born to be physically or mentally deformative. There is a chance, and there are research papers which have proven to that effect. A surrogate mother who is genetically related to either of the biological parents is nearly impossible to find, since a family member volunteering for surrogacy is a very rare scenario. The mother being genetically related to the fetus is also a potential danger, as studies in the past have shown babies born with deformities and health problems since parents were genetically related. Also, in a state like India, it is very pertinent to also observe that to find a genetically related mother, it also brings sort of a shame. It's not very socially accepted in our current society. Altruistic surrogacy is not currently accepted in the kind of society that we live in. It creates a restriction for the intending couple or the intending woman to become a parent. Article 14 of the Constitution states that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory. The doctrine of reasonable classification has been understood to mean that class legislation is prohibited when adopting a law. Additionally, the classification must pass the test of intangible differentia, with the Act's aim being related to the classification. Legislation must avoid unjust discrimination by giving advantages to a class of people or by arbitrarily picking individuals who lack distinguishing traits. If I may draw my ladyship's attention to page number 24, paragraph 59. By penalizing commercial surrogacy, the state not only eliminates individuals' liberties but also fails to strike a balance between individuals' liberties and societal control. The Supreme Court expounded in State of Maharashtra versus Indian Hotel and Restaurant Association, a total prohibition of bar dancing is unconstitutional, which has already been cited by my co-counsel. Likewise, a blanket prohibition on commercial surrogacy, permitting only altruistic surrogacy, violates Article 19(1)(g) of the Constitution. It not only falls short of the purpose of the Act 2021, but plays to the disadvantage of surrogate mothers who now not only will be bearing a child not of their own, but without any monetary compensation. Such an ask is not only horrendous in nature, but also an exploitation of her own body. However, it is pertinent to note that commercial surrogacy not only generated revenue for the surrogate mothers, but also made a significant contribution to the country's commercial growth. The current legislation threatens the job and revenues of several people by prohibiting commercial surrogacy. Women who opted to become commercial surrogacy during the process of commercial surrogacy largely came from an economic, social lower strata. Compensation earned by way of commercial surrogacy has helped these surrogate mothers to provide for basic needs for themselves or their families. Also, prior to commercial surrogacy getting outlawed, these women had a remedy under the Act upon the exploitation of any nature from the intending couple or intending woman. The sudden prohibition under the Act not only affects the livelihood of these women, but makes them all the more vulnerable, since now, if exploited, they do not have any remedy to seek under the present laws. Thus, the Act fails to strike a balance between rules and rights, divulging a legislative process which lacks the expertise necessary for combining the two successfully. The prohibition of commercial surrogacy is in violation of right to livelihood and right to reproductive autonomy contained in Article 21 of the Constitution. Even though surrogacy is not specifically mentioned, but the same has been incorporated in the broadest interpretation by the Supreme Court in various decisions cited below. If I may draw my ladyship's attention to page number 25, 63, paragraph 63 and 64. The right to control one's body and to reproduce is a pivotal fundamental right recognized by the Constitution under Article 22, which has been stated as the Supreme Court in R. Raj Gopal versus State of Tamil Nadu held the right to life encompasses the right to privacy as stated. Individuals have the right to make choices about family, marriage, reproduction, motherhood, and childbirth. The Supreme Court in Consumer Education and Research Center and others versus Union of India held that the term life as defined in Article 21 of the Constitution has a far broader meaning and encompasses the right to subsistence. The same premise was upheld by the High Court of Bombay in Ogla Tellis versus Bombay Municipal Corporation. The Act 2021, by prohibiting commercial surrogacy, not only makes the surrogate mothers impoverished, but also deprives them of an integral chance of being financially independent in today's time when women are exploited heavily into prostitution and other forms of illegal activities. Thus, the prohibition of commercial surrogacy denies these women the right to livelihood, which is widely recognized under Article 21 of the Constitution. The right to parenting and the right to reproduction are beyond the constitutional sphere of the state. Thus, any decision of the state to interfere is an infringement of the fundamental rights. The right to life enshrined in Article 21 of the Constitution encompasses the right to reproductive autonomy, including the right to parenting and conception. If I may draw my ladyship's attention to page number 26, paragraph 66. The Supreme Court in Devika Biswas versus Union of India expounded that women have the right to reproductive rights, which include the right to carry a child to term, the right to give birth, and the right to raise children. Additionally, they encompass the right to privacy, dignity, and bodily integrity, thus confining surrogacy to heterosexual couples and widowed or divorced women within a specified age bracket and denying reproductive options to LGBT individuals, single individuals, and elderly couple violates its Article 21. The next paragraph, 67 also. The Constitution prohibits the state from interfering with an individual right, which is also applicable in the case of a child being born naturally or via surrogacy. The High Court of Andhra Pradesh in BK Parasarthi versus Government of Andhra Pradesh held that the state's interference with procreation constitutes a direct infringement on one's right to privacy, which was recognized as a component of the right to life under Article 21 in KS Puttaswamy versus Union of India, where the bench held that privacy of any person encompasses personal authority relating to the body, mind, and ability to make choices. The High Court in the present matter also agreed with the decision of the US Supreme Court in Jack T. Skinner versus State of Oklahoma, which characterized the right to reproduce as one of the basic civil rights of a man. Indian courts have also abstained from stating that the right to procreation is not a basic human right, which further strengthens the argument for right to procreation. The right of a woman to make reproductive choices, including the choice to procreate or abstain from procreating, comes from within the ambit of a personal liberty under Article 21 of the Indian Constitution. The same was affirmed in Suchita Srivastava versus Chandigarh Administration. Reproduction is a private matter in a woman's life, and decision should be solely made by her and not by the state. If a woman wishes to be a surrogate mother out of her free will and consent by way of executing a legal contract between the parties for legal consideration, then the state should not interfere in this decision. The state's argument that commercial surrogacy leads to human trafficking does not hold since under Section 43B4 of the Act 2021, no woman is allowed to act as a surrogate mother more than once. I would like to seek permission to deal with a sub-issue, that is the legal validity of commercial surrogacy contracts in India. Much obliged. The contract is a voluntary, deliberate and legally binding agreement between two or more competent parties. A contractual relationship is evidenced by an offer, acceptance of offer and a valid consideration, which is legal in nature. In India, the legal principles governing contracts are codified in Indian Contract Act of 1872. According to the Act 1872, a contract is an agreement enforceable by law. An agreement consists of reciprocal promises between the two parties. Therefore, to create contractual obligations, there must be both a proposal and an acceptance. That, with reference to the above, in a commercial surrogacy contract, there exist two competent parties, the biological parents or an individual mother and the surrogate mother, who forms a contractual relationship. The former offers a legal consideration to the latter to be a surrogate mother of their child, and the latter, when accepts the offer with her free will and consent, enters into a legally executable contract. The contract also contains contractual obligations to protect the rights of the surrogate mother along with the intending couple or the intending woman. It is of primary importance to find if contracts for the purpose of commercial surrogacy come within the ambit of unlawful object or consideration. In accordance with the Act 1872, a contract is said to be lawful only when all essential ingredients of a contract are satisfied and the contract is executed between the parties for lawful consideration. As per Section 23 of the Act 1872, every agreement of which the object or consideration is unlawful is void, and the object of consideration is unlawful if the contract is immoral. Thus, to decipher the legitimacy of contracts for commercial surrogacy, it is important to find out if the consideration offered is lawful or if the contract in itself is immoral. If I may draw my ladyship's attention to page number 27, 74th paragraph, last para, the last line, the Supreme Court in the landmark judgment of Baby Manji Yamda versus Union of India and another upheld the validity of surrogacy contracts in India. The US Court California, in one of its cases, Johnson versus Calvert, where the court ruled that surrogacy contracts do not involve the sale of a baby. The word moral or immoral are not defined under Act 1872, but Supreme Court in Gherulal Parak versus Mahadevdas Maya and others expounded that the intent of the Act 1872 was to give the word immoral a restricted meaning. The limitation imposed on it by the expression, the court regarded it as immoral, clearly indicated that it was also a branch of the common law and should therefore be confined to principles recognized and settled by courts. It was further identified by the courts that all judicial decisions confined immorality to sexual immorality under Act 1872. The court further identified that all judicial decisions confine immorality to sexual immorality. In surrogate contracts, there is no sexual activity between the surrogate mother and the intended biological father. Hence, a surrogacy contract shouldn't be constituted as immoral. The Act of 2021 fails to strike a balance between rules and rights with respect to commercial surrogacy and should be amended with keeping in mind every individual's constitutional and fundamental rights in accordance with Article 14, 21, 19, 1G of the Constitution. There could be certain provisions that the state could introduce under the Act, such as treatment available only in government hospital, certain mandates to be added in the commercial agreement when executing a process of commercial surrogacy. Until further amendment in the legislature, the decision pronounced by this court be further declared as a law of the land under Article 142(1) of the Constitution. It is the need of the hour. A well-rounded legislation regulating surrogacy should be pronounced. It is humbly prayed that the provisions of the Surrogacy Regulation Act 2021, to the extent that they prohibit unmarried couples from availing surrogacy, are unconstitutional, that the provisions of Surrogacy Regulation Act 2021, to the extent that they prohibit commercial surrogacy, are unconstitutional, that every intending individual, irrespective of gender, married or unmarried, be allowed to avail the facility of commercial surrogacy, that the above be declared as a law of land under Article 141 of the Constitution. Thank you.
speak about Article 19(1)(g), 19(1)(g)(6) also refers to a reasonable power of the state to impose reasonable restrictions. Power of the legislature, the parliament or the state, to impose reasonable restrictions. So in this case, there are restrictions which are imposed by prohibiting a commercial surrogacy or ensuring that the surrogacy takes place only once. Are these not reasonable restrictions to ensure that the women are not exploited?
Your Lordship, Your Ladyship, the restriction the restriction on commercial surrogacy completely bans from opting a surrogate mother who's genetically non-related to the couple. And the only solution that is left for the intending couple or the intending woman is to opt for an altruistic surrogacy where they have to go for someone who is genetically related to them. This scenario has various difficulties, namely the most important of two being that it is very difficult to find someone in the family, in the close-knit family or even as a distant relative who will volunteer to do this service for you. Since we all know that being pregnant is very difficult task, and secondly, there is a high possibility that the child which would be born will be with deformity, if the child is born with deformities.
So what you're trying to say that these restrictions which are imposed make the working of the act totally unworkable because of these practical difficulties.
Yes.
Is the counsel audible? Counsel seeks permission to address the bench collectively as the ladyships. This is Counsel 1 appearing on behalf of the respondents and shall be dealing with sub-issue 1. My co-counsel will be dealing with sub-issues 2 and 3. Counsel seeks permission to firstly give a brief about the facts and then proceed with the arguments. The Union of Zindia is a nation following a quasi-federal form of government. A large section of society cannot conceive a child normally and opt for surrogacy. It came to the notice of the government about the misuse of this procedure. Hence, the Parliament of Zindia passed the Surrogacy Regulation Act of 2021, and all the appropriate authorities, boards, and rules were constituted in the respective states on 1st of January 2022. The Act defines surrogacy as a practice where a woman gives birth to a child for an intending couple with the intention to hand it over to them after the birth. It is permitted only for altruistic purposes for couples who suffer proven infertility or disease. Mr. Ajay Shinde and Ms. Kavita Vartak are in a live-in relationship and reside in Bombay, the capital of Madhya Rashtra. The said couple was trying to conceive a child for a very long time, but due to certain health-related complications, they were unable to do so. The couple was interested in availing the facility of surrogacy, but later on found out that they were not eligible for the procedure. Moreover, they were unable to find the appropriate surrogate mother defined under the Act. Thereafter, they opted for commercial surrogacy. The live-in couple were able to find a woman named Mrs. Vidya Renuke, who agreed to give birth to the couple's child on the basis of monetary consideration. Thereafter, the couple entered into an agreement with her for commercial surrogacy dated 2nd January 2022. The couple then approached the appropriate authority under the Act and misrepresented that they were a married couple. Accordingly, they got the required permissions and certificates under the Act. Counsel shall proceed with the arguments. Issue 1.1 is the legal status given to live-in relationship couples. Under the Constitution of Zindia, live-in relationship is given considerable validation. This comes under Article 21 of the Constitution, which guarantees to its citizens the fundamental right to life and personal liberty. That is to say, that the relationship shared by the petitioners, Mr. Ajay Shinde and Ms. Kavita Vartak, is not illegal under the eyes of law, even though it is considered as immoral in the eyes of society. In the case of Kamini Devi versus the state of UP, the petitioners are at liberty to live together and no person shall be permitted to interfere in their peaceful living, as right to life is a fundamental right ensured under Article 21 of the Constitution. However, according to the Surrogacy Regulation Act of 2021, the petitioners do not fall under the ambit of Section 2H, which defines couples as a legally married Indian man and woman above the age of 21 years and 18 years respectively. Even though the petitioners qualify this section of the Act in terms of their age, they do not fulfill the criteria of being legally married, leading them not being eligible to avail the procedure of surrogacy. In the instant matter, it is an admitted fact that the petitioners were in a live-in relationship and lived with one another for 15 years. However, even with this provision of Section 2H existing in the Act, the petitioners went ahead with the process of availing surrogacy. The purpose of this Act to make altruistic and not commercial surrogacy available only for legally married Indian couples was to stop the exploitation of surrogate mothers and see to it that children are not abandoned through this process. Furthermore, Article 14 forbids discrimination but allows reasonable classifications based on intelligible differentia. The twin test laid down for reasonable classification is that classification must be found on intelligible differentia, which distinguishes those that are grouped together from others, and the differentia must have a rational relation to the object sought to be achieved by the Act. The classification done of unmarried couples from legally married couples is rational in nature, as a law may be constitutional even though it relates to a single individual if on account of some special circumstances or reasons applicable to him and not applicable to others. That single individual may be treated as a class by itself. In the present matter, legally married Indian couples are treated as a class by itself in the ambit of the Surrogacy Regulation Act. This so is done to protect the surrogate mother and even more for the child born through this procedure. The legislature correctly understands and appreciates the needs of its own people, that its laws are directed to problem made manifest by experience and that its discrimination are based on adequate grounds. The department related Parliamentary Standing Committee on Health and Family Welfare in its report stated, the upbringing of a child is a big responsibility equally shared between a father and mother and is a lifelong commitment. The Council of Respondent humbly state that the base of a live-in relationship lacks commitment. Live-in partners are not bound by law and safety of the child born through surrogacy will be questionable. In Indian context, both parents, a mother and a father, should be there to raise a child. A single parent might not be able to fulfill his or her responsibility completely. There stands to be no liability for live-in couples as they can get separated or married whenever they decide to. The Council of Respondent humbly submit before this Honorable Court that the provisions of the Act of prohibiting unmarried couples from availing surrogacy is constitutionally valid as it does not violate Article 14 on grounds of reasonable classification and the said provision is not arbitrary. If your lordships are satisfied with the arguments, Council seeks permission to call upon the co-counsel.
Is the Council audible? Council seeks permission to collectively call the bench as your ladyship. Council will be dealing with two sub-issues. One, whether the present case falls under the ambit of commercial surrogacy. The present case of the respondents is that the couple who have opted for commercial surrogacy under the said Act who are legally not married, the status of the couple is that they are in a live-in relationship. As the Surrogacy Act has been explicit about who can avail the process of surrogacy under the definition of the couple 2H of the Surrogacy Regulation Act 2022. To bring to your lordship's ladyship's notice, they have been prosecuted under Section 420 and other relevant sections of Indian Penal Code. They have come before this honorable court with not with clean hands and all, and the petition is afterthought of the cover-up of their offences and misdeeds. The instant case, in the instant matter, the couple who has opted for surrogacy are not legally married, are not legally married couple, and the couple approached this appropriate authority under the Act and misrepresented that they have been married by presenting the fake marriage certificate and showing their eligibility as a married couple. Furthermore, to state that the surrogate mother was also not informed about the couple not being married and are staying in a live-in relationship. The mother, belonging to a poor family and is financially unsound, was not able, and hence was not able to make her ends meet. She constituted this commercial surrogacy agreement with the intending couple. The process of commercial surrogacy is a wide known for buying and selling of embryos for trading, sale or purchase of the embryos, or buying and trading the services of the surrogate mother as explicitly mentioned in Section 2G of the Surrogacy Regulation Act. To bring to the notice of this Honorable Court that the said agreement was executed through misrepresentation which lead to total injustice on the part of the surrogate mother. In the instant matter, the surrogate mother agreed on becoming Mrs. Renuke, who agreed on becoming the surrogate mother for the unmarried couple for only on the consideration of monetary benefits. This was done as she had a 3-year-old son to look upon after, and her financial condition was deteriorating. Hence, the intending couple and Mrs. Renuke entered into an agreement of commercial surrogacy. The present case is an evident case of monetary consideration other than the nominal expenses of medical treatment and the child care which was given to the surrogate mother by keeping her uninformed about the couple being unmarried. In the present case, the intending couple being in a live-in relationship for more than 15 years and are not legally bound by marriage, hence they are not eligible party to avail the services under the Surrogacy Act. Yet, the couple through illegal means opted for surrogacy and the surrogate mother was unaware about the same. The constitutional validation of the surrogacy should be restrained as many such cases were brought into the notice to the appropriate authority. Hence, the commercial surrogacy cases should be constituted and should be strictly scrutinized, and proper verification should be done to ensure the smooth process of surrogacy. Council would like to proceed with the next sub-issue. Constitutional validation of commercial surrogacy. It is most humbly submitted before this Honorable Court that the provision of Surrogacy Regulation Act of prohibiting commercial surrogacy is constitutionally valid. To bring to your leadership's notice, we have to also understand that under Section 2D under Section 2R of the Surrogacy Regulation Act, there is a mention about ART Act, which goes hand in gloves with the Surrogacy Regulation Act. The Act contemplates services being availed by two classes of the beneficiary, a woman above the age of 21 years and commissioning couple, that a man between the age of 21 years to 55 years and a woman between the age of 21 years to 50 years who are legally married and infertile. Similarly, in the Surrogacy Regulation Act, also two classifications are being stated as intending couple mentioned under Section 2R of the Surrogacy Regulation Act, that is a married Indian men and women above the age of 21 years and 18 years respectively, for whom surrogacy is necessitated to become parents, and an intending woman, that is an Indian woman who is a widow or divorcee between the age of 35 years to 45 years and who is also a mother to her own child. To furthermore prove that the ART Act very clearly states that its objective is merely to regulate and supervise ART clinics and banks and provide an avenue to safe and ethical ART services. The object of Surrogacy Act is to create a framework of the boards and authorities to regulate surrogacy procedures. Under the ART Act, commissioning couple has to satisfy the requirements of being legally married and should be above the age of 23 years and 26 years for women and men respectively. Infertile and have no existing children. Even in a heteronormative setting, it excludes newly married couple. For example, a married couple where the woman is of 18 years and woman between the age of 18 years and 23 years, and a men between the age of 21 years to 26 years who are desirous of having children, or those who have a existing child but are unable to have another child and wish to do so via surrogacy. To bring to your leadership's notice, Section 3, Subclass 2 of the Surrogacy Regulation Act is regulating surrogacy as a type of ART service, provides for complete prohibition of commercial surrogacy. Under Section 4, Subclass 2B, only female altruistic surrogacy is permitted. That is, it should be undertaken not for the monetary gain, but by the member of the beneficiary's family or relatives in a clinic that is registered under the said act. In this vein, a woman who has agreed to be a surrogate mother must be ever married, have her child of her own, and be between the age of 25 to 35 years. Therefore, it is submitted that this essence is included just because the legislature was of the opinion to enable the couple who has a child to seek help of a surrogate mother who is genetically related to the couple or the intending woman. It was never an intention of the legislator to give birth to a new illegal industry. In India, from ancient times, having a child is considered to have a great social status in the society. But unfortunately, due to medical complications, some married females are not able to reproduce a child. Therefore, the technology of surrogacy was a boon to such couples. But if commercial surrogacy is allowed, many females who don't want to undergo the pain and the after effects of the pregnancy will choose the option of commercial surrogacy. It is a two-way process. The females who are not financially stable will get into the industry of being commercial surrogate, and the people or the couple who intend or who are financially stable and sound can opt for the procedure just because they are financially sound. Furthermore, if such misuse is allowed, every financially weak woman would see commercial surrogacy as a way to earn money as her bread and butter. But little we have considered the side effects of giving multiple births, which may lead to a huge medical issue. Intersectional exploitation of women in India runs rampant in repetitive spheres where it can be sexual or economical, and thus it is a legitimate state aim to protecting women. However, rather than a palestric state curtailing the autonomy of a woman to make intelligent decisions about their bodies, a lucid understanding of reproductive justice and balancing the act is necessary. To furthermore, character assassination of a woman, character assassination of a female honor, and calling into question the womanhood of many are likely to be anticipated when concerning the stigma of infertility. The right to dignity emanated from the right to life under Article 21. In many parts of our country, childbearing is still preserved to be most important and responsible job of the married woman. Altruistic surrogacy as a policy answers to any of the exploitive racket of commercial surrogacy. To bring to your ladyship's notice, after deteriorating from any deterioration from the state sanctions, Ideal Family now carries criminal liability under Section 40 of the Commercial Surrogacy Act, which the petitioners have been already convicted under for misrepresentation of commercial surrogacy agreement between the commercial surrogate and misrepresenting marriage certificate. That an intending couple or a woman who seeks any aid of any medical practitioner contemplated under this act to not follow altruistic surrogacy or undertake commercial surrogacy shall be punishable with imprisonment which may extend to 5 years and a fine which may extend to 5 lakh rupees. To bring to your ladyship's notice, altruistic surrogacy is the way out as it is a provision given under the Surrogacy Regulation Act 2021. The person who is able and willing to conceive for no monetary payment to do so, restrictions on autonomy in terms of being ever married or being between the age group of 25 to 35 years of age and related to be the intending couple of a woman smash the arbitrariness and severely curtail reproductive options available in Indians who are already facing decline in fertility rate. The objections primarily from the concern over the fact that a woman has no choice in this matter. Their reproductive capacity is totally in the hands of the men, controlled in fact, accused by them for their own benefit. It is a kind of baby selling for money. Treated as a breeder, her reproductive capacity is sold and resold as a commodity. Women are pressurized into surrogacy as a way to economic pressure at their home. If commercial surrogacy is been unconstituted, it may also lead to a market like brothel, which the woman will be forced to conceive the child. It will also set a very bad impact on the society at large. The act so passed was done for protection of women from exploitation and to also safeguard the children born from surrogacy. Therefore, it is most humbly submitted that the provisions of the Surrogacy Regulation Act to extend of prohibiting commercial surrogacy and to extend of providing unmarried couples from availing the surrogacy is constitutionally valid. If your lordships are satisfied with the contentions, council seeks permission to proceed with the prayer. Whereof, in the lights of the facts stated, arguments advanced, and authorities cited, the respondent humbly prays before this honorable court that it may be pleased to adjudge and declare that the provisions under the Surrogacy Regulation Act 2021 are prohibiting the unmarried couples from availing surrogacy in the view of the facts that this honorable court be pleased to declare the live-in relationship couples are not entitled to avail the services as they fall under the category of live-in relationship couples and violative under Surrogacy Regulation Act 2021. The Honorable Court be pleased to declare that the present case falls under the ambit of commercial surrogacy provided under Section 2G of the Surrogacy Regulation Act. This Honorable Court be pleased to declare that the provision of Surrogacy Regulation Act of prohibiting commercial surrogacy is constitutionally valid. Any order may pass, any order, decree or judgment as this Honorable Court may deem fit in the interest of justice, equity, fairness and good conscience. For this act of kindness, the respondent shall be duty bound forever pray. Indeed, your ladyship.
Answer that. See, this particular act makes a classification so far as intending couple. You can call it parents, in fact, intending parents, and even individuals are concerned. How will you explain that this doesn't violate the principles of Article 14?
Your Ladyship, when we talk about Article 14, we talk majorly about intelligible differentia. Intelligible?
You must agree that this act makes a classification.
Indeed, Your Ladyship, this act is made to protect the safety of the woman and the child born out of a legally married couple. And when we talk about Article 14, primarily when we talk about 14 is about intelligible differentia. The fellow petitioners have failed to explain the difference, the intelligible difference, why it shouldn't be that that a live-in relationship couple can avail the process of surrogacy. It is also stated it is also possible to seek equality under Article 14, providing the legality of live-in relationship couple. Therefore, at this stage, it is very premature to compare the live-in relationship couples with the married couples. Your Ladyship, when we talk...
Intending woman.
Indeed, Your Ladyship. It is stated under 2S, intending woman means any Indian woman who is a widow or divorcee between the age of 35 to 45 years of age and who intends to avail the surrogacy procedure. The single woman who, the Surrogacy Act is widely stating that any woman who, if she might be divorced or she might be divorced or she might be a widow, can avail this procedure of surrogacy through altruistic surrogacy, not through commercial surrogacy. As the council in their arguments pleaded that anyone who is ready to conceive a child for the intending couple has the right to avail this procedure, but it should not be commercial. It should be altruistic in nature. It should not be through monetary. It should not be for monetary benefits. It should be out of their own will.
Recently, the Supreme Court Justice Chandrachud judgment on termination of medical termination of pregnancy act, where he included an unmarried woman into the definition of a woman and traced that right to Article 21. So in this case, since a married couple is differentiated from a live-in relationship couple, drawing the same analogy, can it not be said that it is violative of Article 21?
When it comes to the question of surrogacy, over here, the main purpose is also the protection of the child. So that is why in a live-in relationship couple, commitment lacks. That's where the department also responded on this, that they want the child to be born in a family where he gets the protection both from the father and the mother. But when it comes to a live-in relationship, it would probably lack. That is why this classification is made.
My lady, may I get a chance for rebuttal? First of all, my lady, I have an objection with the issue that they have stated. This is the Supreme Court, not the trial court. They have stated regarding one Mr. Ajay Shinde and one Miss Vidya Renuke and the other accused. I may draw your attention to the Moot proposition. If one of the coordinators could please provide my ladies with the Moot proposition. Page number 7, my lady. My lady has it. My lady, the second issue is whether the present case falls under the ambit of commercial surrogacy or altruistic surrogacy. This is the Supreme Court, and this is not the matter to be contested over here. As you can read from the third line onwards, what we are contesting over here is we are challenging the constitutional validity of the provisions of the Act, not whether the petitioners have committed a case of commercial surrogacy or not. My ladies may please note that we are not allowed to contest the sections of the trial court in the Supreme Court. We cannot waste that time over here, my ladies. And as per the third line, the final rounds are supposed to argue only upon the issue whether provisions of Surrogacy Regulation Act 2021, to the extent that they prohibit commercial surrogacy and to the extent that they prohibit unmarried couples from availing surrogacy, are constitutionally valid. I put it within notice that the respondents have digressed from the issues that were given. Moreover, my ladies, they question the legitimacy. Now, if I may rebut to the arguments that they have given, they question the legitimacy of a live-in relationship. If I may quote a very recent judgment of the Supreme Court, Edithil Walson case, it is clearly stated in this judgment, this very court has held, it is settled law that if a man and a woman live together for long years, there would be a presumption of wedlock. The Supreme Court itself is granting a presumption and it is giving legality to live-in relationships. And therefore, under Section 114 of the Indian Evidence Act and Section 50 and Section 4, the court may presume that live-in relations are legal and that the couple is married legally. Moreover, they spoke regarding the welfare of the child. My ladies might be very well aware that even in case of a live-in relationship and in case where a child is born out of wedlock, the child is entitled to every right that a legitimate child is entitled to. All the parental rights, all the legal rights, all the succession rights are granted to the child, and the welfare of the child is very much taken care of. Moreover, in the facts, they stated that there is a large section of society that is unable to conceive a child, and that there is a decline in the fertility levels in the country of India. My ladies, it is completely contradictory, because if it is so, and if they understand that there is actually a decline in fertility, shouldn't the act be more not restrictive than restrictive? That is why we humbly plead, my lady, that the eligibility criteria of the act may not be so narrow and it may be amended to include as many people as possible with the necessary provisions. Moreover, they stated that the woman has no choice in this matter. We would like to bring it to the notice of this Honorable Court that now is when the woman has no choice in this matter, because monetary compensation is first of all not provided to the surrogate mother, and furthermore, a woman inside a family, if she is pressured, she can also be pressured by the family into agreeing to the consent, because in a customary country like India, where people give a lot of importance to families, if there is a barren couple in the family and someone from the family may also pressurize someone who is someone who can bear a child, they can force them to bear a child, because there is no contract that is there with specific clauses. In this case, they are actually exploited, because it is completely altruistic surgery and surrogacy, and we don't even know if there is a free consent involved, because they will obviously be pressurized by the other members of the family to bear the child of the genetically related intended couple. But in the case where they are not related to the couple, the surrogate mother will be in a better position to argue for her rights, because she does not know the couple anyway. She is doing it for a monetary consideration. There will be a valid contract under the Indian Contract Act, which will be enforceable in the court of law. While in altruistic surrogacy, where the family is pressurizing her, we do not know what happens inside a family. We may not know whether the consent actually is present or not. Moreover, my lady, they stated that this procedure can turn into a situation like a brothel. May I bring it to the attention of my ladies that surrogacy is allowed only once under the Act. It can in no way, even if commercial surrogacy is allowed, surrogacy will be allowed only once under the Act. How can it turn into a brothel-like situation? Because the ladies will be, we have that much faith on the respondent, the Union of India, that they will check and make sure that when they give the eligibility certificate, they will ensure all provisions are followed. And one of the provision is that the lady should have not been a surrogate mother before. Therefore, it is absolutely unfounded on why they are saying that it can become a brothel-like situation. Moreover, my lady, they also stated that under this provision, if commercial surrogacy is allowed, women will be controlled by men. As per my earlier submission, if only altruistic surrogacy is allowed, in that scenario, my lady, women will be controlled by men, because the family members will have a say into whether they can bear a child or not. The consent under this act, the consent of the lady is to be given, and that can be availed only if there is a specific contract specifying all the laws. The respondent can very well mandate clauses that is to be put in the contract to ensure regulation. As they said, the fertility line is declining, and in every way, the respondents should agree with the petitioner that they should allow a broader scope of people to avail services under this Act. Moreover, my lady, the objection is taken into consideration. The counsels for the petitioners would like to rest the case.
Counsel seeks permission for a rebuttal. To bring to the ladyship's notice, I would like to address all the issues stated in the rebuttal point by point. Firstly, even though this case is before the Honorable Court for constitutionality validation of this Act, the fact still remains undisputed. That the petitioners have committed commercial surrogacy, and hence to cover up that, they have approached this Honorable Court for challenging the constitutionality of the Act. Furthermore, to state that the basic purpose of the Surrogacy Regulation Act was to prohibit exploitation of women. And in their arguments, the fellow petitioners in the argument stated that the society is not accepting altruistic surrogacy, but they are of an opinion that commercial surrogacy should be unconstitutionalized. There is a lot of discrepancies in what they have stated, that commercial surrogacy is done for buying and selling of the embryos, as it is stated in the clause of commercial surrogacy under the said sections, and altruistic surrogacy is not for monetary purposes. Hence, any person can avail that facility. And when we talk about the surrogate mother being the surrogate for once, indeed, she can give birth to, she has the right to, she can come under the act of being an intending woman, or to be a surrogate mother under the section of the surrogate mother. But you have to also consider the health of the woman, as she has already been a mother to her own child. So when we talk about being a brothel, I'm talking, the council is talking about, it shouldn't be repetitive of any woman to give birth to a child, because if commercial surrogacy is being provided, it will be an industry altogether, because it will support their finances.
Surrogacy can be only once. How do you correlate it with the commercial surrogacy and exploitation? And exploitation occurs when the woman is forced to go through it again and again.
Your ladyship, indeed your ladyship, but when we are talking about when the woman has to go through that surrogate pregnancy for once, you also have to consider the fact that the Act also is restricted that she should be mother to her own child first. And being a mother to her own child also gives her health issues. And being and availing the process, if commercial surrogacy is constitutionalized, availing the process, it will turn into an industry where people, it will be like buying and selling. Even though it may be a process, or it may be constituted that it will be an industry altogether, just to provide, and it can be a profession if commercial surrogacy is constitutionalized. Furthermore, on the other side, there are plethora of judgments where it is cited that child born naturally to an unmarried couple which are in a live-in relationship, the child born is also given legal status, and all the legal rights are protected under section 25 of CRPC of the mother and the child. There is no new regulation or statute to protect the rights, protect the legal rights of the unmarried couple. Even though this Honorable Court has validated validated live-in relationship, but there is no such statute regulating the legality of live-in relationship couples or the unmarried couples. Council would like to rest the case.
Maybe that's a different thing, but you have amazed us. Very well done.